sponsored by the Program in Public Law, which is supported by an alumnus of the class of 1978, Richard Horvitz. The Program in Public Law, as most of you know, is responsible for much of the noon programming at Duke Law School on public issues. And this includes the brown bag lunches, the talks by public figures, faculty debates and panels, outside speakers, as well as the spring and fall constitutional law conferences. This program has enormously enriched the intellectual life of the law school, and particularly on issues ranging from national security and terrorism, other separation of powers issues, gay marriage, gun control, judicial selection, affirmative action, and many more. Overlapping many of these topics is often the institution of the U.S. Supreme Court. So we are greatly honored to have here today Linda Greenhouse, who covers the Supreme Court for the New York Times and who is the author of the intellectual biography of Justice Harry Blackmun. To introduce our speaker, I'm going to turn the program over to Professor Chris Schroeder, Director of the Program in Public Law.
The Great Lives series brings to the law school prominent jurists, lawyers, and other individuals whose lives have intersected with the life of the law in noteworthy ways. Today, we are honored to have in today's speaker a rare combination of someone who has spent nearly 30 years covering the institution of the Supreme Court and who has just completed a biography of one of the most significant justices to sit on that court in our lifetimes, the late Harry Blackmun. Linda Greenhouse, after graduating from Radcliffe College, began work at the Metro desk of the New York Times, covering New York politics. After a decade there, she was offered the opportunity to cover the Supreme Court for the Times, which institution was also prepared to send her to the Yale Law School for a master's degree in preparation for that assignment. She accepted both invitations and proceeded to earn something many of you would covet if it were available, a one-year law degree. She started covering the court in 1979 and has been there ever since. Of the sitting justices, only Justice John Paul Stevens now predates her at the court. Her coverage of the court earned her the Pulitzer Prize in 1998. The available sources of information on the court have grown enormously over the years since she started covering it, and now include everything from instantaneous cable TV punditry to numerous websites and even more numerous blogs. Through it all, the journalism of Linda Greenhouse stands out and continues to stand out for anyone with a serious interest in the court's business and continues to be must-reading for any such person. Such is the esteem in which she is held that when lawyers interested in the court talk about the greenhouse effect, they're most likely not talking about global warming, but rather the possibility that some justice's opinion has been influenced by some cogent piece of analysis that has appeared in one of her columns. In 2004, she was offered a rare opportunity by the executors of Justice Blackmun's will to have a head start prior to the public availability of the justice's papers at the Library of Congress so that she could prepare a series for the Times on Justice Blackmun's career that would give it some depth and perspective. This work led to the book project, which she completed last year, Becoming Justice Blackmun. Today, Linda will discuss Justice Blackmun, the Supreme Court more generally, and her own career in covering that institution with our own Walter Dellinger. Walter is Douglas Maggs Professor of Law and head of the appellate practice at O'Melveny & Myers in D.C., and someone who is no slouch as a Supreme Court observer himself, having argued cases before the court in both a public capacity as Solicitor General of the United States and in a private capacity as well, and having written and spoken on almost every aspect of constitutional law, theory, and practice. Linda, it's a treat to have you with us today, and to turn the proceedings over to you and Walter.
Linda? Good afternoon. Let me start by asking Linda to tell us just a little bit about your family.
My family, okay. I grew up outside New Haven, Connecticut, for those of you from Yale, Hamden, Connecticut. where my father had grown up. He was a Yale graduate, class of 1939. He was a doctor. My mother was from New York. Went to Hunter College, majored in chemistry, had a brief career working for the Celanese company. Then, like women of her generation, stayed home and raised my sister and me, and we went through public schools, and then we both went to Radcliffe. My sister stayed at Harvard and got a PhD in anthropology, which she teaches at Princeton. And
When did you first think about being a journalist? When did that moment hit? Was it some 8th grade paper assignment, or was it much later?
Really my junior high school newspaper, which I worked on. My high school newspaper, which I was the editor of. I mean, I always was writing as a kid. I think what, made me think of it as a career, I mean, I grew up, and you and I are sort of the same generation, and I wasn't all that clear about a career path. I didn't have any female role models, really. The only woman I knew who was what you might call a journalist was a wonderful woman in my town named Mary Bull, who wrote a society column for the weekly paper, and that was, about all. But in, I guess, 9th grade or so, or 10th grade, I read Theodore White's fabulous book, Making of the President in 1960, and I was crazy about John F. Kennedy. He was a great hero of mine. I was madly in love with him. And here was this book in which reporters played a rather major role. It was the first, for those of you who haven't read it, I highly commend it. And it was the first sort of, bird's eye view of a presidential campaign. And he was a journalist, Theodore White. And these guys were flying around the country, with my hero. And I thought, this is a living. People are doing this, as a job. And so that's what really kind of got my attention.
How did you get started at graduation? How did you get from there to the New York Times?
Well, in college, I worked for the Harvard Crimson. I was an editor of the Crimson. And I, then was really developing a notion of doing this for a living. But again, it was a little hard to see how to get from there to there. I was the Harvard stringer for the Boston Herald, one of the daily papers in Boston, and they were happy to print my articles, and it was a kind of a tumultuous time in the late 60s, and so Harvard was making news, students were demonstrating this and that, and so I had a body of real grown-up clips, so it came as rather a disappointment that the Herald would not see me for an interview because they didn't hire women. And
what year?
1968. Mm-hmm. And the Boston Globe wouldn't see me for an interview. And I really wasn't sure what to do. And I applied for a few fellowships. Most of the good fellowships at Harvard at that time, which my Harvard colleagues on the Crimson were plucking off, were not open to women. I don't mean to sound like I'm whining. But just so you know the history. I don't wallow in this stuff, but it's a fact. These are facts. I took the civil service exam. I thought maybe I'd work for the government. My mind was kind of blank. But then somebody told me, one of my Crimson friends who had graduated.
One thing, how struck were you by the exclusion from being interviewed? Was that something that you thought of as a clear and enormous wrong, or the state of the world, or somewhere in between?
Well, that's a very good question, because, this was just a few years before the kind of second wave feminism. And looking back, you think, this was like outrageous. But we didn't have, I say we, all of us, Radcliffe students who were, 1/4 or 1/5 of the Harvard undergraduate population and were really second-class citizens in many ways, but we were supposed to be, happy to be there. And we were, by and large. And we didn't think in political, we didn't have the vocabulary of feminism. It just, it struck me as unfair, but like the way of the world, yes. Mm-hmm. People were marching, but they were marching about the war in Vietnam. They weren't marching about women's rights. That really just hadn't happened yet. So anyway, somebody told me that James Reston, a columnist at the Times, very famous in his day, had an internship, a personal internship program that he had modeled after a Supreme Court clerkship, where he would take a kid from college every year to work for him for a year as his assistant. So I applied for that, wrote him a letter, and was invited down. He had never hired a woman, but the draft was on. And he had had a couple of guys drafted out from under him. And, you know, so I owe my job to the war in Vietnam. And he hired me, and so that was just fabulous. I mean, I remember getting the call in my dorm and just running up and down the halls screeching because, you know, this was late in the spring of senior year, and as I say, I really didn't have much of a clue as to what was going to become of me. So it was a job based in Washington, so I was very interested in politics. I'd always wanted to live in Washington. So I happily moved to Washington, but within weeks, he moved to New York because the Times was having one of its periodic management crises, and he had been called on to be executive editor of the paper. So I moved to New York and stayed there for the next 10 years. After my year with him, got a chance to try out for the staff, and just stayed. So.
All right, so you did the Metro section, you did Albany. I want to move forward to coming to the court. How intimidating a thought was it to jump into such a technical area and to say for the court to hand to you? I mean, the Times Supreme Court beat had been the purview of Anthony Lewis, who was probably the most famous legal journalist in the century to that point, whose book, Gideon's Trumpet, is well known to everyone. So this was a giant, and you were going to be summoned from Albany to take over this.
Right. Now, Tony had then been off the beat
for a while.
There had been a few intervening people. But yeah, the first thing I did, well, it was presented to me as more or less of a package. You know, you will go to Yale Law School for a year, and then, as Abe Rosenthal, the then executive editor, said, depending on your grades, you will then cover the Supreme Court. I sent him my transcript, but anyway. So the first thing I did was call Tony Lewis, whom I didn't know, and he was up in Boston, and I was going up to Boston actually for my 10th college reunion, and asked if I could come and see him, which I did, and I asked him for advice about, you know, what to take in law school and so on, and he gave me very good advice. He said, whatever you do, take federal courts, take a federal jurisdiction course, which would not have occurred to me. Take a statutory course, take antitrust or something like that, which I did, and he gave me lots of good advice and became a mentor and lifelong close friend and so on. So I did that, and I think I was pretty naive when I started the beat, actually, because I didn't know what I didn't know. I figured, okay, I've had a year of law school, Yale, pretty good, you know, did pretty well. I know this stuff, but, you know, what do you know? So, you know, what you don't learn in class in law school, I don't believe, is, you know, a sense of the life of the Supreme Court procedure, just sort of how things work on the ground. So, I came down in the beginning of October term 1978, and as luck would have it, the New York newspapers were on strike. It's the last time there was a strike. It started in August of '78, and who knew how long it was going to last? And so the term was starting, and I really didn't know what to do. I had just, you know, moved to Washington for this, and the strike could end any day, so I figured I'd better be prepared, even though they weren't paying me. I mean, I wasn't crossing the picket line. But I would go up to the court every day, and I was starting to read cert petitions. And that summer, the National Law Journal had been launched. It was a brand new publication. And the editor of the Law Journal hired me to do a weekly report for them on the cert grants. So that gave me a paycheck and gave me a, you know, focus. And the strike lasted until November.
Wow.
But the day the paper resumed publication, I was really, you know, ready to go. So I had a sort of a break-in period without having to really test myself against the daily deadline. It actually worked out pretty well.
Have you ever looked back at your earlier reporting and seen things that you would do differently now, perhaps in connection with the book, which we'll come to?
Oh, yeah, not so much in connection with the book, but just in connection with my own self-confidence and ability to draw on a base of knowledge. Yeah, I mean, my stories in the early years, I think, were, I mean, I don't think they were, bad in retrospect, but they were kind of formulaic. The Supreme Court ruled today that such and such, and maybe some law professor said this about it, and so on. And they weren't as inherently analytical in my voice as I try to make them today, because I've come to think that you ask yourself, okay, what does the New York Times reader need to know about what just happened today at the court? So assume a person, a reader, I like to assume much like myself before I started covering the court, that is to say somebody who's generally aware of what's going on in the world, interested in public affairs, is reading the New York Times. So you're not pandering to them, you're not dumbing the stuff down, but you can't assume that they know the context, how did this case get there, what happened, what are the implications of this, some sweep to it, and I try to build that in to the story, and that requires, often some essential analysis of how it got there and where it's going, and I think that's a more common feature of my stories now than it was at the beginning.
Some of you may be aware of this, others will come to be aware of it as your careers in the law go forward, but every year there's this extraordinary day, sometimes it happens twice, late in June, when the Supreme Court will hand down the most important decisions of the term, all of which have backed up. Even if they were argued in November, December, January, they tend to all back up as people are working on the 4 or 5 historic opinions, and the court, with no sense of public relations, will hand them all down in the same day. There's one entire volume of the U.S. reports that's a single day's
right.
work. And the next morning in the New York Times, with plops on your doorstep, there'll be sometimes 4? What's the most?
No, 4. I tried 4 once and it almost killed me. 3.
But 3 stories on major cases that may run 1,000, at least hundreds of pages together. And with a deadline that certainly used to be more like 7 o'clock.
Yeah.
I'm not through the majority opinion of the first case. When Linda has filed, could you give us a lot of people think that there's something, you've made some pact with
No.
How do you do this?
Adrenaline. Yeah, I mean, you just, I mean, I think it would be like anything. It would be like, some airborne ranger, parachuting. I mean, it's a very focused activity, and it doesn't necessarily relate to the rest of life. I mean, it's just very, sometimes I read those stories and think, how did I do that? And it really is adrenaline, and I have a, I do try to do my reading at the court. I have a little cubby at the court, and then we have a big bureau in Washington. And actually, I have more peace and quiet and privacy at the court than in our office, which is a complete mess with CNN and C-SPAN going and people yelling into the phone. And I just got a new neighbor who just moved next to me, and he's a big, loud talker. And anyway, so I sit at the court and I read, and I just try to read everything once, through and underline and take notes, so that when I go back to the office to start writing, it's all in there. It's all kind of crammed in there, and then I can sort of.
And I would think your extraordinary preparation all term long gets you in a position to really understand the cases when they come down in a way that if you were starting from scratch would not be possible.
Oh yeah, you couldn't, I mean, I've hopefully, I mean, if I'm doing the job right, I've known these cases since they arrived as cert petitions. Because just to back up, so I look at, every week the court has a conference, and so every week they circulate to the press a conference list, and those are the cases that are ready to go to the court for the decision on whether to grant cert. So the petition is in and the response is in, and I look at every paid case. There are 2 categories of cases: paid and the informa pauperis, which are basically cases from prisoners, and that's the majority. That's now about 2/3 or more of all the cases, and that's like finding a needle in a haystack. So I don't look at those, but I look at every paid case and make my own judgment as to whether it's going to go anywhere, or whether, if the court denies it, that could also be a story. So I've known the case, and if it's a big case, I wrote about the case at the cert stage, and I read the merits briefs, and I attended the argument, which I never go to unless I have read the merits briefs, because even when you've read the briefs, sometimes it's very hard to follow the argument. But if you wander into a Supreme Court argument and you haven't read the briefs, you're just taking up space. You're just wasting your time. And so by the time the opinion comes, again, if I've done all that correctly, at least I know I'm intimately familiar with the universe from which the court is selecting the things it's going to decide. It's because it's not going to decide everything in every case, and there's often, a narrow way to decide a case, a broader way, a statutory way, a constitutional avoidance, rewriting of the statute, whatever, and it's the preparation that lets you assess which of the various options they've chosen and what the import of that, of the roads taken and not taken might be.
One of the pieces of yours, Linda, that I recall most vividly was one of the relatively few where you described the scene outside the courtroom and in the courtroom behind where the advocates are. You were there long enough to have covered both Bowers against Hardwick, where the court held in 1987 that the court upheld Georgia's criminal prohibition on homosexual sodomy over a powerful dissenting opinion by Justice Harry Blackmun, which we will have occasion to come to later. Then fast forward many years later to a couple of terms ago, when the court once again considered this issue in Lawrence against Texas. And your coverage of the argument was quite unusual, because you talked about the audience and the plaza outside the court and how different it seemed between Bowers against Hardwick and Lawrence against Texas. You want to say about what you perceived that?
Yeah, well, when the court granted Lawrence, it was pretty clear they granted it to overturn the Texas sodomy law, because there was no reason to grant the case. It came up through the Texas Supreme Court, so there wasn't a conflict in the circuits. It was a kind of a free grant, a very well presented case. The cert petition was on a very high level, and it was just clear what game was afoot. So it was a big deal, and the argument was a big deal. It was a question of how far the court was going to go. They could go a sort of a narrow equal protection route, or they could, at the narrow end and at the broad end, they could disavow and overturn Bowers against Hardwick, and one didn't know where on that spectrum. But I guess it was during the argument that I sort of gradually became aware, and I'm not sure how exactly, that the courtroom, the bar section, was filled with gay members of the Supreme Court bar, who I never knew was gay. I mean, it didn't occur to me to wonder who's gay. Nor did I know that Paul Smith of Jenner and Black, who argued the case, is gay. I mean, I knew Paul. It never occurred to me one way or the other to even think about it. But that this was a community that was, coming together in a very subtle way, almost outing themselves in this place, the Supreme Court, which in Bowers had been so hurtfully dismissive of their claim to constitutional attention, where Justice White had said in Bowers that the claim in the case was facetious, right? That was the word he used. And so, kind of a badge of dishonor had been, placed on this community by the Supreme Court, and now, perhaps this would be undone. And so I just felt,
I think you said at the time of Bowers that there were undoubtedly people who were gay in the audience, but they were there very quietly, as if they had been there for the ERISA case that was being argued next. I mean, that when Bowers was argued, no one in a law firm who would have come up, would have wanted to acknowledge that they were there because they had a personal interest in the subject.
Right.
And
the world has just changed.
And I think what you said was was a very striking piece. However the case comes out, the argument of it and the fact that it was a gathering so publicly of prominent lawyers in major law firms who were gay and were there as part of, and were publicly so, was itself an enormous shift that it was
Yeah,
quite.
and I think, it was because of the individual justices' realization that this had occurred, that this shift had occurred, that led them to grant the case and to rule the way they ruled.
You cover issues of enormous emotional weight and controversy, whether it's the death penalty, abortion, gay rights cases that you write about. And like everybody else, like any of the rest of us, you will have feelings about those issues. Like everybody else, you'll have your own thoughts and opinions. Do people ever call into account your sort of objectivity if they know your views? You ever run into issues about what you do about those views when you're a correspondent? Has this ever become an issue?
Well, of course, I don't own the real estate in the papers, so anything that appears under my byline has been read by probably, at least 3 editors and maybe 4 or 5 just in the production process. So it would be really unusual to have a kind of a tendentious or, slanted kind of piece get in the paper, actually. So I don't think anybody could kind of call that into account. I had an interesting experience just about a year ago, though. It was just sort of an interesting moment. I was walking up to the court from Union Station. There were a lot of people around, and I was just very focused on getting up to court, and I didn't wonder why so many people were around. But I gradually became aware that I was walking through the annual anti-abortion anniversary of Roe demonstration. That's why all these people were around. And I had my ID, my Supreme Court ID tag around my neck because I was going to go through the court security. And a woman came up to me to ask me for directions to someplace she was going. And I stopped to answer, and she looked at my tag and she said, I know you, I've seen you on television. She said, please tell me you're pro-life. And so I had a moment when, okay, what to do? She knew who I was and so on, and you're not supposed to have an opinion. So I said, actually, I'm pro-choice. And she, just her face crumpled, she said, oh no. She said, please reconsider. Think of the babies. She started giving me this, and I said, look, I respect your opinion, which I do. I said, I just don't agree with you. I'm sorry, have a nice day. And I went back to the office afterward. I was sort of, puzzled by my response. It was an odd moment, and I recounted this to my colleagues, and to a person, they thought I was an idiot to have outed myself as having an opinion on this matter. And I said, maybe it was good for this woman, who evidently thought of me as some kind of celebrity because she saw me on television, whatever that means, to think that, someone who seemed to her like a normal person, or maybe even someone she would look up to, had a different opinion of the matter. And I'm glad I said what I said. And I think it's too bad that we're in such a sanctimonious era in, our politics and our journalism that it's somehow questionable that somebody would say in an encounter like this, I have an opinion on this. So anyway, that's a long answer to your question.
Speaking of abortion, Harry Blackmun. This is Becoming Justice Blackmun, Harry Blackmun's Supreme Court Journey by Linda Greenhouse, which, as Chris Schroeder noted, she had extraordinary access to the wealth of materials that Justice Blackmun left behind, and with instructions that they become public 5 years after
His death.
5 years after his death.
Which was 10 years after he left the court.
And Linda says, the opening words are of the book, the prologue. You say, Justice Harry Blackmun gave the country a great gift in making these materials available. Can I push on that? Do you see a downside of having this kind of material available, internal memoranda, notes between justices, what other justice law clerks are thinking? Is there any downside to having this material available this soon?
Well, the incumbent justices think there's a downside. None of them were happy about it. You know, what Harry Blackmun could not have anticipated is that the court that was sitting at the time these papers became available 10 years after his retirement was the same court that he left, exactly, except for Stephen Breyer, who replaced him. So that was just an unusual period of stability. So it exacerbated the court's sense that this was too soon because they're all still there. You know, but I mean, there was really nothing in the papers, and I looked, of course, and everybody who looked, you know, that was sort of like embarrassing. I mean, it was the people doing their work, you know, giving it their best shot for the most part. So I don't think it will change the way the court operates. But I gather there's a consensus among the incumbent justices that 5 years was too soon, and none of them will release their papers that soon. And Justice O'Connor was asked about, when she announced her retirement, was asked at the conference she was at what her plans were, and she said, for her papers, and she said, well, she hadn't actually decided yet, but she said, I'll tell you one thing, there's not going to be any becoming Justice O'Connor. So it'll be a while. I
know people that argue before the court now go and he graded all the advocates before the court. I haven't yet gone by to see what grades I got from Harry Blackmun and the case I argued.
He was a tough grader. That was no grade inflation with him. So.
Yeah, well, that's good to know. When you look at his life, and I know you looked at, and you consciously and very wise, I think, confined the book really to the Supreme Court papers. But from what you know about Blackmun and his life, is he someone who seemed destined for stardom in life?
No. I mean, he had a very unpromising beginning. The family was quite poor. His father had trouble making a living. I think he suffered as a young man from depression. I think he suffered all his life from depression, actually. Not diagnosed, but I think it's clear from reading his self-reflections and his diaries. So, very risk-averse. When Charles Wyzanski, a Harvard Law School acquaintance, urges him to come down and work in the New Deal, Wyzanski was Solicitor of Labor, writes multiple times to Blackmun, come, leave your boring law practice, come down to Washington and work with me. We'll have so much fun. Blackmun just doesn't go because it's a risk. So no, you would not have picked him out of a hat to be destined.
So he grows up in St. Paul, goes to Harvard College and Harvard Law School.
Goes to Harvard College on a Minnesota Harvard Club scholarship. Mm-hmm. Otherwise, he wouldn't have been able to leave the state.
Goes back and practices law, gets appointed to the Court of Appeals, I guess had a successful enough law practice.
Well, got appointed to the Court of Appeals because he had clerked after law school for Judge Sanborn on the Eighth Circuit, who became a mentor and really a very important figure in his life, kind of a father figure, and Blackmun was a son figure to him, and they vacationed. It was really an unusually close relationship, and so he then really proposed Blackmun for the vacancy when he decided to retire. So it wasn't completely fortuitous. And Blackmun, by that time, was not really a nobody. I mean, he had had a very successful law practice in Minneapolis for the biggest firm in the state, and then had become general counsel of the Mayo Clinic. In Rochester, he was head of the Rochester, Rotary Club and a kind of figure around town, and knew all the political figures in the state on a first-name basis. And so I remember when, just to project forward, when David Souter was nominated to the Supreme Court, and I followed him around as he made his courtesy calls in the Senate, and there was one room and some reporter shouted from the back, Judge Souter, how does it feel to be plucked out of obscurity? And Souter said, I didn't think I was that obscure. So it's kind of the same thing.
Well, the kindergarten class at Van Buren Elementary School, the 1914 kindergarten class at Van Buren Elementary School in a working class neighborhood in St. Paul, though no one would have known at the time, was a very unusual elementary school class because two of the little boys in the class would wind up on the United States Supreme Court. Now, what are the odds on that? If anybody has a calculator, that at the same time, and I'll come back to that later, what it was like, the relationship between these two boys, but I need to bring it up now because I assume it had something to do with the fact that Harry Blackmun, who was not the kind of legendary Court of Appeals judge of a Richard Posner or a Nino Scalia, the sort of
right.
names that show up on the Supreme Court prospect list, winds up on the U.S. Supreme Court from the 8th Circuit. Did his friendship with the Chief Justice Warren Burger have something to do with that, or what else?
Oh, for sure, yeah. I mean, by the time Burger, who was very ambitious and very political, by the time Burger's on the Supreme Court as Chief Justice, Nixon's first appointment, he makes it a goal to get his friend Harry on the court. So he definitely played a major role in that, no doubt about that.
What was the book on Judge Harry Blackmun? I'm now often wondering about the predictability. But President Nixon had made it quite clear that he wanted to name what in political discourse he would call law and order conservatives who would be tough on crime. Certainly Warren Burger fit that mold. His opinions, he was a dissenter from what was a generally liberal D.C. circuit, quite much a law and order person, became the chief. Can you recall what the book was on Harry Blackmun, what the prospects, what people thought he would be as a justice?
Well, you're right that Nixon's goal for the court was law and order, and the salient issue of the day was the criminal process revolution under the Warren Court. I mean, this was, of course, before Roe and so on. So that's what mattered. And John Mitchell, Nixon's Attorney General, assigned the vetting of Harry Blackmun's Eighth Circuit record to a young lawyer in the Justice Department, William Rehnquist, and who was an Assistant Attorney General. And Rehnquist looked through Blackmun's record, and he'd been on the Eighth Circuit for 10 or 11 years, so it was a substantial record, with an eye to, what's his record on law and order issues, and he was pretty conservative and remained pretty conservative on the criminal side. I mean, there was never much of a sort of a greening of Harry Blackmun on the criminal side other than the death penalty and habeas, capital habeas, that kind of stuff rather late in the day. So Rehnquist reported back, yeah, he's fine, no problem. Now, when you look back at the Eighth Circuit files, which I didn't do very systematically, they're voluminous and they're numerous, but the files are, most of them, kind of spare, so it's a little hard to get the full context. But there is some interesting stuff in there that you can project forward and see signs of Justice Harry Blackmun. He adopted in the Eighth Circuit a practice that was incredibly useful as a biographer. When he was presented with a case, every case he encountered, he would dictate or write a memo to himself for the files, where he would take his law clerk's bench memo, whatever, and his own reading of the briefs and bringing whatever he was bringing to this issue, and just write down, his response, so that it's a kind of an internal dialogue with himself that you can see him working through various issues. So For instance, one Eighth Circuit case, and I forget the name of it now, presented the question of, does the Eighth Amendment's prohibition on cruel and unusual punishment apply to prohibit corporal punishment in a state prison? Does it apply to that degree to conditions of confinement? And there was really no law on this, or the law really looked the other way. This was kind of terra nova. And Blackmun wrote for the court. It was a case from Arkansas. The Arkansas prison officials used a certain kind of strap with little, metal things on it to beat prisoners. And, the state of the laws was handed to him. There was no constitutional problem with this. And Blackmun writes a really interesting memo to himself saying what he feels is wrong with this, and writes an opinion and says to himself, I view the Constitution as something that evolves over time to reflect conditions of society. And this is his constitutional view. And he writes an opinion that did get a fair amount of notice. It was the first federal appellate decision that applied the Eighth Amendment to something like this. And there's a couple of others where you see him, really a little bit edgy in the law of his time. So he wasn't simply a law and order judge in these kind of broader, interesting issues.
In his early years on the court, certainly people were not surprised that he was a Nixon appointee. Thurgood Marshall thought him insensitive to the needs of the poor, didn't understand how the world looked for them when he would have upheld filing fees for bankruptcy. I think Wyoming Exchange was visits from surprise visits from to people on welfare from government officials, even into the 70s and 80s. In gender discrimination, he didn't think the male-only draft or a high degree of veterans' preferences in Massachusetts, or even the exclusion of men from the University of Mississippi versus Hogan. None of those struck him as sex discrimination, but there is something about becoming Justice Blackmun about the role that getting the assignment in Roe versus Wade played in his life. So could you talk a little bit about the Roe and the assignment and its impact on what that role that might have played in the transformation or evolution of?
Yeah, I mean, it's my thesis that it was the fortuity of Blackmun having been assigned to write Roe, and his response to the public response to Roe. Not so much the fact that a lot of people didn't like the opinion, but the fact that it was attached to him personally, both from the anti and the pro side, that he was both demonized and got, hate mail by the tens of thousands of letters, all of which he read and saved, pickets, death threats on the one hand, and was lionized and made a hero of the nascent women's rights movement, in which he hadn't signed up at all. I mean, he viewed the abortion issue really as an issue of the rights of doctors. His friends, the doctors whom he had served as general counsel of the Mayo Clinic, to practice medicine in a way they saw fit in the best interest of their patients without risking going to jail. That's what really, grabbed him about the abortion issue. So he resisted this at first. I mean, because he would say, it's not my opinion. It's a 7-2 opinion. I was assigned. I wrote the opinion for the court. It was a collective effort, which it was very much so. So he resisted this, but it was so relentless over time, and his personality was such that he did incorporate in his own self-image in a very profound way a role as the creator and the defender of abortion rights in America. And the more embattled Roe became, the more embattled he felt personally inside the court as the climate changed. And so my thesis is that this role that fate placed him in sensitized him to issues of not only women's rights, which became obvious over time, but issues involving the poor, The first case in which the Roe majority fractured and left Blackmun in dissent were the trio of cases in 76, I guess, Mayer against Roe and Beale against Doe and so on, where the question was, is the state obliged to pay for abortions for women who are too poor to afford them? And it's there that Blackmun's abandoned by Berger and by Potter Stewart and by Lewis Powell and all the members of the Roe majority, and he's left to say there's another world out there that the court fears or fails to recognize, so he goes in that direction. And even in things like a major part of his constitutional legacy, commercial speech. He's the father of commercial speech as a First Amendment doctrine. There was really no First Amendment protection for advertising when he came on the court, and the first case that he encounters was essentially simultaneous with Roe, was the Virginia case Bigelow, where the question was there protection for a newspaper publisher who violated Virginia law by publishing an ad for an abortion referral service. And the court finds, in Blackmun opinion, finds First Amendment protection for this. So that in many areas that on the surface wouldn't necessarily seem to be related to abortion, it changed him and pushed him and led him in these directions.
Let me ask you, as they often do these days, the people that actually know how to do these interviews, to read a passage. Linda is both a great reporter and a great writer. This is the conclusion.
Okay. All right. Walter's marked what I'm supposed to read here, so. It's actually the last paragraph of the book. Blackmun often grumbled that he knew he would, quote, carry Roe to my grave, unquote, despite having spoken for a 7-2 court and notwithstanding his hundreds of opinions in other areas of law. His complaint was valid, and yet, in so many ways, Roe against Wade was not just another case. The world attached it to Blackmun in a manner that few Supreme Court decisions are ever linked to their authors. The popular attribution of Roe to Blackmun alone was a distortion of the court's reality that baffled him at first, and he resisted the notion that he was Roe's only creator. Eventually, though, he yielded. Continued resistance would have been futile in any event. In yielding, he locked Roe in a tight embrace and never let it go. Its defense carried him in new directions, like I've just been saying here. To commercial speech in Bigelow against Virginia, the abortion advertising case, to the other world out there of poverty and need in the abortion funding cases, and most significant to his eventual commitment to the struggle for women's equality in the sex discrimination cases. Warren Burger could never have suspected that in turning to his reliable friend for one unwelcome assignment, he was launching Blackmun on a journey that would open him to new ideas and take him far from their common shore of shared assumptions. Burger sent Blackmun into dangerous waters without a life preserver and then turned aside. But Blackmun kept swimming. In defending his legacy, he created his legacy. He became Justice Harry Blackmun.
Thank you.
Thank you both very much, and especially to Linda. That was very informative and interesting. In about 10 minutes, I'm going to invite you all to go outside to join us in a reception for our speaker. We have time for a few questions, and I'm going to take the prerogative of just asking one, which is, can you say something about this 80-year relationship with Warren Burger that was so strong until the two came together in rather mature adults on the court, and from then it went downhill fairly cataclysmically.
Yeah, I mean, just briefly, they were really, really close friends, and I knew that. I mean, the trajectories of their lives and the way they intersected was common knowledge. It wasn't a revelation. Here that they grew up together, and Blackmun was best man at Burger's wedding, and then they end up sitting together on the Supreme Court for 16 years, by the end of which they were so estranged that they were barely speaking. What his papers reveal, it's not so much why it fell apart, but how far it had to fall. One of the most unexpected things about the papers was a trove, I mean a treasure trove of correspondence between Blackmun and Berger over decades. The oldest letter I found was Berger to Blackmun in 1929, and they wrote all through their own young adulthood, their 30s, their 40s, their 50s, when Berger was in Washington on the DC circuit and Blackmun was back in the Midwest. And Blackmun saved both sides of the correspondence. He saved everything Berger sent him, and he made carbons of all of his outgoings, so you get a two-way conversation. It's just incredibly rich and strange, really. So, what happened? I mean, some people say, well, it was Berger turning away from Roe and so on. My sense of it was no one thing. It wasn't that they had different views of the law, because Blackmun maintained decent relations with Rehnquist, with people he didn't agree with. I think it was, by the time they ended up at the court, they were both in their 60s. They had built up images of one another from, halfway across the country, almost a romantic kind of image each of the other that just couldn't be sustained in the sort of crucible of conflict and tension and high stakes at the Supreme Court. They each disappointed the other in painful ways. And it was just a kind of a mismatch, and very sad. They both had they were both to blame. They were both kind of, rigid and unduly sensitive, and it's kind of too bad it had to happen that way.
John.
I should know this, but don't. Did Blackmun have much of a family?
Yes.
And what was the relationship, if anyone could determine it, between the women in his family and Roe as it ultimately evolved?
He has three daughters who were young women growing up in that time. What I learned, not from the papers, but because of something that she published about the time the papers were released, is that his middle daughter, Sally, who's a lawyer now, corporate lawyer in Florida, got pregnant before Roe in her sophomore year at Skidmore, and married the guy and left school and had a miscarriage. So she was 19 years old or whatever, and out of school, got divorced, no husband, no, her life this was a horrible impact. She obviously then got her act together and went back to school and married and went to law school and so on. But, Blackmun could not have been unaware of the impact of, and whether she would have had an abortion had it been legal, I have no idea. I've gotten to know her, but I never asked her. But, he was aware, as anybody would have been, of what life was like in the days before Roe. So he couldn't have been unaffected by this, but I think his, the medical profession's coming around to a pro-choice position is what really got his attention.
Jim?
I'd be grateful to hear if you could talk about how your access to sources on the court has changed over time, and whether Bob Woodward's The Brethren changed things fundamentally.
Well, I don't really have access to sources on the court. I don't really have sources on the court. And of course, neither did Woodward in the sense of, contemporaneous sources, because by the time The Brethren was published, I think the most recent stuff they had in the book was 5 or 6 or more years old. So he wasn't doing, daily reporting. Now, I was always kind of skeptical about The Brethren, but I have to say the Blackmun Papers really back up. The Brethren looks very good in light of what's in the papers. And I was also rather shocked to learn from Blackmun's papers that he was a source, that he gave 2 interviews to Scott Armstrong. So, I give high marks to The Brethren, but I don't have sources myself.
Is it the case that what's important about the court is what it says it's doing, because that's a performative utterance, unlike other areas? So, if some intent that's not disclosed in the opinion is not going to be influencing subsequent cases. So it's an odd way in which the court's a very public institution as well as a very private institution.
Yeah, although not to be too, kind of formalistic about it. I mean, I'd love to have sources at the court. And there's, questions right now that I would love to have answered. I mean, for instance, they've been sitting on a couple of really meaningful cert petitions, such as the Jose Padilla case and such as the Bush administration's petition in the Eighth Circuit so-called partial birth abortion case. And I don't know what's going on there, whether they're just waiting for Alito. They'll have their first conference with Justice Alito participating on Friday of this week. And so there'll be orders issued next Tuesday. But yeah, if I had a source up there, I'd say, what is going on with these cases? And we'll never know, we'll never really know what went on with the cases until somebody's papers come out, which, will be 20 or 25 years from now.
Or until we read your column the day after the conference. And so
Right.
on that, let us thank Linda and Walter once again, and we are adjourned.